Okiya Omtata says that he's ready to prosecute his petition at the Supreme Court on his own without any High Court advocate. He is seeking the highest court in the country to rule on whether or not there was a presidential election on 26th of October, banking on High Court ruling which determined that all returning officers in the 290 constituencies were gazetted illegally. Omtata says he will also be seeking Supreme Court's determination on whether or not, if the election is upheld, President-elect will have legal grounds to rule Kenyans in 4 counties which did not surrender their sovereignty since no election was held in those areas. Duncan Kayemba reports.
Well, basically, the High Court washed its hands, like Pontius Pilate. It washed its hands and said, take him to Herod. If you remember the story of the Passion of the Christ.
53-year-old Andrew Okiya Omtata Koiti is at it again, preparing himself for yet another legal tussle in the corridors of justice, although this time round he will be playing in a Super League. Omtata has filed a petition at the Supreme Court of Kenya. Supreme Court petition number 18 of 2017, Okiya Omtata Koiti versus IEBC and its chairman Wafula Chebukati as first and second respondents respectively, and all the August 8th presidential election candidates as interested parties. Picking up from where the High Court left, he wants the Supreme Court to rule, among other things, whether indeed what took place on Thursday, October 26, was a fresh election.
We are no longer talking of a presidential runoff. We are talking of a fresh election, complete with nominations as done in other scenarios. Because what has happened is that the Supreme Court has nullified the election. And for purposes of understanding this issue, when an MP loses his seat through a nullification, the court nullifies the election of an MP, and then a by-election is called. It usually begins with nominations that are open to everybody. You don't say that those who vied at the last election come, because what is invalidated is the complete election.
But perhaps the elephant in the room is the interpretation of Article 138, Section 2 of the Constitution that says, if 2 or more candidates for president are nominated, an election shall be held in each constituency. Omtata argues that should the election be upheld, then President Uhuru Kenyatta cannot rule the 25 constituencies where the exercise did not take place. Hence, residents did not surrender their sovereignty as per Article 1, Section 2 and 3 of the Constitution.
When you hold an election, you are asking the people, do you want to exercise your power directly, or do you want to exercise your power through the executive? So when they come and participate in an election, they are saying, we have agreed to exercise our power through the executive. And then whoever comes out as the winner in that election has authority, moral authority over them, because they participated in an election. And that's why an election must be held in each constituency. But when you come up and say that they don't matter, that one is a declaration of civil war, that you are going to rule them whether they like it or not. And that's why the Supreme Court must put its foot down and restore order in this country. And that's why it's very, very important to understand what an election is. It's not a game of numbers. Numbers are a byproduct of an election. The purpose of an election is to get the commitment of the people that we are surrendering our sovereign exercise of sovereign power directly to the institution. And that's what the IBC missed, and that's what I heard them talk in Bomas, that the remaining areas, even if we hold an election, cannot change what we have, was a declaration of civil war.
Also on his list is the question of who are the individuals who participated in the repeat presidential election.
So who would give a court power to nominate candidates? And therefore, when the court has disqualified, has annulled an election, nothing is left of that election. There have to be new candidates. So these 8 people who are said to have been on ballots during that exercise, I don't even call it an election, that exercise that was held on the 26th of October, where did they come from?
As it stands, the Omtata petition number 18 is the only petition before the Supreme Court, but the window for filing petitions to challenge the re-election of President Uhuru Kenyatta ends on Monday midnight. Surprisingly, Omtata is his own man and will prosecute his petition single-handedly without any High Court advocate. Yet, he is a layman on matters law and says he will only require between 4 to 6 hours to plead his case.
It's not the number of lawyers on a case that matters. It's the law and the facts.
The President of the Supreme Court, Chief Justice David Maraga, has directed all respondents to file and serve their responses with written responses by 5 p.m. on Tuesday, 7th November 2017. The matter will be mentioned on Friday, November 10 at 9 a.m. The first time Okiya Omtata got an opportunity to argue before the Supreme Court on his own was in 2016, when he appeared as an interested party in the Justices Kalpana Rawal and Noi retirement case. 2017, he returns to the very Supreme Court under Supreme Court petition number 18 of 2017. Will he be lucky this time round? Duncan Hemba, KTN News, Nairobi.